Supreme Court is there, Millard. I am also not very well aware of it. So, Millard, he wants to. Millard, that is the main predicament. But Millard, let it be, because I am adhering to. So, Millard,
may I just
because he was not allowed.
Correct. In my matter, nothing of that sort is there. In the other matter, when that is called, my lord, your lordship will deal with it. In my matter, nobody has gone.
In my contention is, Millard, with regard to the same subject matter, SLP has been filed, caveat has been discharged from our side. We have already served on the caveators. Now, Millard, that matter, Honorable Supreme Court, is in session of the matter. Now, Millard, this is arising of the same subject matter. The prayers which have been made by them over here, they are wanting certain documents which.
No, Mr. Ganguly or not. State of West Bengal is not being permitted to come.
No, CBI is not allowed. CBI and Union of India is not. CBI and Union of India is not being allowed to come in. See, because in our petition, we have made CBI a party.
Mr. Dotto is not being permitted to come in.
Well, let CBI be allowed and Union of India also be allowed, Millard. CBI and Union of India is there, Millard, they will be allowed.
Second matter, on behalf of respondent number 2, I have with me 2 juniors, sir. Pardon? No, I am that time. We are in a.
It's like that.
On behalf of respondent number 2, I am the senior counsel. Advocate on record is there and assistant advocate. That I am submitting. No.
All organized. Very well. Then may I just proceed with my matter, my lord?
Millard, Mr. Raju has been granted access. Has been granted.
While he's there, yes.
Insofar as the ED matter is covered, the ED is the second matter. I believe the prayers before the Supreme Court are almost identical.
My lord, identical. My lord, why? My lord, will kindly bear me for 2 minutes.
He's here.
Yes.
Is there?
Sir,
Yes.
Sir is there, and sir will have address.
Yes. The prayers before the Supreme Court are almost identical.
My lord, identical.
Sir,
my
unmute
lord,
yourself.
My lord,
Kindly unmute
bear me
yourself.
for 2 minutes. Yes.
Is there?
Sir,
Yes.
Am I audible? Am I audible, Your Ladyship?
You are. Yes. Before
We have filed
Identical. My
unmute
lord,
yourself.
my lord, kindly
a lot of disturbance, Your Ladyship. May I?
Yes. Yes. Please.
We
Yes.
have filed 2 petitions in the Supreme Court.
You are. Yes.
We have filed two matters in the Supreme Court. Being a lot of writ petitions, criminal number 16 of 26,
Please.
and 17 of 26, wherein we have made same prayers. Maybe we made additional prayers, and we have said that if the Supreme Court entertains those matters, criminal
Please
number
give me a minute.
16
Please give me a minute. May
I
I?
can't. You're not audible.
May I
We have made same prayers.
mute
Maybe we
yourself?
made additional prayers. And we have said somebody is speaking, Your Ladyship. Somebody is speaking. I can't.
Sir, kindly wait for some time.
Why
Maybe many people have logged in and they have kept their audios open.
Speaking,
So
Your
that
Ladyship. Somebody is speaking. I can't.
they can be muted from here. Kindly wait for some time. Many people have logged in and they have kept their audios open.
Speaking, Your Ladyship.
I think he's
Sir,
mute Mr. Raju.
there is some audio problem from your side.
Mute Mr. Raju. And this is the back effect that is coming. This is the relay that is coming. It was the YouTube because I could hear myself.
Even I could hear
Yes.
something has to be done.
Now it is done, I believe.
May I now speak, Your Ladyship? If
Well,
I'm audible?
Please unmute
Mr. Manika Kuruswamy is also there. This is the relay that she's the lead counsel in my matter. Hear myself.
Even I.
Yes, 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 yes.
Somewhere I do not.
Now
Let
it
me,
is
let
done.
me hear Mr.
May,
Rajat.
may I now
My
speak,
God,
Your Lordship?
everything is being
If I-
played on Mr. Manekar
No
Goswami.
echo, Your Lordship, there's a lot of echo.
He's the lead counsel in my matter.
It is being.
Even I.
Yes, yes, yes.
Somewhere I.
Now it is
Let
done.
me hear Mr. Rajat.
May I now request everybody else not to speak, Your Lordship?
Mr. Manekar Goswami.
Your Lordship, there's a lot of echo.
He's the lead counsel in my matter.
Even I.
अरे आगे क्यों नाची?
Somewhere I.
Now it is
Let me hear Mr. Rajat.
May I now request everybody else not to speak, Your Lordship?
Mr. Manekar Goswami.
Your Lordship, there's a lot of echo.
He's the lead counsel in my matter.
Start hearing,
My lord, what we have, because my lord, I was being led by,
May I now
my lord, what our
request not to
contention
speak,
is.
Your Lordship?
Mr.
But we,
This
may I
because
only submit this, but may I only submit this, Your Ladyship? If
which
I'm
has been filed, SLP which has been filed by us before the Honorable Supreme Court, what we deals with the same call of action with the same subject matter. Now, my lord, will kindly is subject, my lord, but it is intertwined. It is intertwined to that effect that my lord has seen our prayer before my lords.
My lord, here's me.
Now, my lord, their prayers are that threefold. One,
Let us see what our prayers is, Mr.
my
Trivedi.
lord, may I?
Allow me to at
He
least
is actually
indicate.
primarily asking for the.
An
Supreme
adjournment on both the applications.
Why mine? Because I'm not
Why?
in Supreme
Because-
Court.
because
I'm
I
not
have been-
caveated.
They're all connected,
I
they're all
always
connected.
have a right to ask for an adjournment because I am a respondent therein.
Please understand.
As respondent, I have a right.
Let him say.
Now,
then I
my lord,
submit.
it is for my lord.
Let me hear Mr. Banerjee. Let me
Correct.
place his case.
My lord, in that case, my lord, if that is being done, my lord will kindly ensure that my leader is made audible and he addresses this honorable court. Because, my lord, otherwise, my lord, the person who is I am adhering to, if he is not being able to present the case before my lord today due to any reason under the sun, then, my lord, I cannot go handicapped.
Yes,
Let
let me
his case.
place the
You
case.
can always take your stance after that,
Correct.
right?
My lord will kindly, my lord will, in the meantime, my lord will ask that let who is
Oh my God, who's he?
Union of India.
Yes.
Am I audible now, Your Ladyship? Am I audible?
He'll have the
Yes.
first right.
Sir is audible.
If he's challenging the maintainability, he'll have the first.
Can I just say something that this has become infructuous?
Please.
Effectively. This petition will not survive slowly. Why I'll tell your lordship because Marat, if Dr. Goswami could be added.
No,
My lord,
Mr. Raju is also audible.
May I
What
just
we have asked for and what are our grounds before the Supreme Court contains both these petitions. It is not as if it is my petition. I've also said something about the other petition. Supreme Court is said the matter is likely to come up in the Supreme Court within a week. Till the Supreme Court is hearing the matter, heavens are not going to fall. Nothing is going to happen. So let these matters be adjourned.
that is
Your
his
Ladyship,
submission,
kindly have a look.
but now your lordship would hear my submission.
Let
No,
me
no, kindly have a look. As far as their petition is concerned, it is it is mixed with my petition. It can't be segregated. It is not as if the
Why
petition
over
is
there?
can be
No.
segregated.
let
Therefore,
me
let
hear
this
his submission.
let no, ladyship may hear me. Let both these matters be adjourned to a short date. As soon as the Supreme Court hears the matter, we will proceed with the matter. Even otherwise, on the last occasion, if your ladyship recollects, your ladyship had granted the date. My consent was not that there are other matters fixed today, important matters fixed today. We are busy also in that. But the main reason why we want an adjournment is that the matter is same petition, same reliefs is before the Supreme Court as far as we are concerned. As far as their petition is concerned, there are some reliefs which are intermingled with their petition. Therefore, this can be kept after some days. If your ladyship may hear both these matters, I'm not running away from that, but only keep it after the Supreme Court is seized of the matter. And even otherwise, when the Supreme Court is seized of these matters, there are judgments to the effect that this court should not hear the matters. Kindly have a look at one
sir.
judgment,
No.
1986 Supreme Court.
That's
Supplement-
yes. That's settled law, sir.
Then therefore mine is a reasonable request. Mine is a reasonable request. Nothing is going to happen. And there are so many things that I have to say, even as far as that petition is concerned, but I'm refraining from doing so, even as far as maintainability is concerned, because the matter is pending in the Supreme Court. The judicial decorum requires that till the matter is disposed of by the Supreme Court, this may not be heard. It may be that the Supreme Court may say, all right, go, let the High Court decide. But till that time, the Supreme Court orders are passed, this matter may be adjourned. Your ladyship adjourned it on the earlier date for 3 days. A few more days, nothing is going to happen. The earlier date when your ladyship adjourned, they never objected to, they never asked for a hearing. It
Let
was me who asked for a hearing.
That's
My lord,
counsel, sir.
This
my lord,
quite-
I am opposing the prayer of the ED's learned counsel. And if your lordship permit me, I can place my points why I am
You are
opposing.
appearing for?
I am appearing for in the ED's petition
No, I'm-
for respondent number 2.
I also want to place written submissions on maintainability. Give me time to place written submissions on maintainability. What is the hurry? What is the hurry? There is no interim relief. What is the interim relief as far as the matter is concerned? Now kindly have a look. I'm not on merits. Kindly look at their matter. What is the interim relief
Officer,
that they have prayed for?
Guruswamy in the matter. Till the time Dr. Guruswamy is being added, my lord would kindly see
Who is Dr. Goswami in this matter?
Guruswamy, my lord, my leader. She's the lead counsel from Supreme Court.
Where is he?
She is not being permitted.
Will he join court?
That is one. And my lord, your lordship would.
Has he got, has he joined?
Yes, she's done it, my lord. While Dr. Guruswamy is being added, may I just show your lordship page number 16?
Of your application?
Yes, of my application.
Now kindly have a look at the interim prayer. Therefore, there is no
I am
urgent.
very unfortunate that I did not interject him.
No, I'm not completed. I've not completed. Then where the question is, you were
The
interjected. I've
court
not
to
completed.
decide whether the court wishes to hear
Okay.
or
Good
not.
morning, my lady. I'm glad that I was finally allowed to appear.
Now kindly have a look at the
I,
interim relief that they've asked
And
for.
Happy New Year to you, my lady. It's my first appearance in my ladies' court.
Now, kindly have a
So
look.
I am appearing
Kindly
for
have
the
a-
Trinamool Congress here
Dr.
today
Meneka, I'm addressing the
in
court.
item 1.
It's not
Please
complete.
don't-
In item 1.
Now,
Hello,
kindly have a
Mr.
look at
Raju.
the-
Nice to see you.
Kindly have a look
Also,
at the interim relief that they've asked for, page 20. They've asked that they should not divulge leaking, sharing information of the seized article. Those seized articles are seized by them. No, nothing is seized by the ED. Where's the question of any interim relief?
Not merits, sir.
my lady, I was
Therefore-
following the
No, it's not
proceedings
on
on
merits. It's
YouTube.
not on merits. What I'm saying.
I was
is
surprised to
there
hear
is-
Mr.
there is no
Raju
interim
arguing
relief which
maintainability on
requires
his
an
own
urgent
petition.
hearing.
The first time
So
I've heard
why
such
is
an
the matter
argument.
being heard today? When I'm saying that the Supreme Court is seized of the matter.
To make our submissions, I believe.
Mr.
No, I believe we are entitled to make our submissions, Mr. Raju.
I'm
Now,
not saying that.
my
I'm
lady-
not saying that, but you're
my
entitled to
lady,
make it.
I am
But the
here.
Submissions are that the matter should be adjourned.
May I just
until
be
the
allowed to
Supreme
place
decides
my
on the matter.
point? Because I have waited so patiently and eagerly to just be allowed into my ladies'
That's not
court.
my problem. That's not
Yes.
my problem.
No, Mr. Raju, of course, nothing is your problem. But be
Yes.
that as it may,
No,
be
no,
that
no.
as it
Then
may,
Your ladyship may
my,
kindly.
my lady,
I have
what
not
is
finished
before my
addressing the court.
lady?
I have not
What is
finished
before my
addressing the court.
lady is
I have not finished addressing the
Yes.
court.
yes, what is before my lady are two petitions.
But I have not
I am
finished
here-
addressing. If
I
this
am
is the
here
this is the manner in which the
PMC.
proceedings are being done, then your ladyship may do whatever you want. I am not being allowed to complete my submissions.
Let me hear the petition.
Generally, Mr. Raju, judges are allowed to decide the way they
No,
want.
I'm not. I'm not. saying-
Generally, unless
Yeah,
you're
I'm
saying
not
something
about
else
the
that we are
I
hearing
am-
for the first
yes,
time
but
today.
you are interjecting and you're objecting
Yeah.
and you're intervening when I am addressing the
Yes,
court.
I am the petitioner. Obviously,
thank you.
I am the lead petitioner. Obviously, I will want to place my case, Mr. Raju.
No, no, nobody
Forgive me
said
for
that.
expecting this.
No, no,
Forgive
it's
me
not.
for
It's not a
expecting
question
this. Yes, my lady, may I just say that the petition, the lead petition before you is the one
Your ladyship is not
602
allowing my
of
request.
2026.
You are rejecting my request.
602 of
Rejecting
2026.
my
This is
request.
in the matter of the Trinamool Congress versus the Union of India. Now, in this case, my lady,
I can't hear your ladyship.
our point is
I can't hear your ladyship.
simply this.
Complete, I'll hear you.
Allow.
Whenever a maintainability body is being raised, my lord, it should be decided first.
Learned counsel has preliminarily said that this has become infructuous. That is what he wants to submit.
Allow the person to address the
Absolutely.
court.
So
My
that
lady, I am not sure why
Allow
Mr.
the
Raju
person
and
to
the
complete
state
his
is so
submission.
worried. They have
Allow the person
searched,
to complete
they have
his submission.
stormed. Now they don't want us to argue. They don't want
What
my
is all
lady
this?
to
What is all
hear.
this?
I mean,
What is
you
all
know,
this
it is an
drama-bazi?
extraordinary sign of bullying, in fact, if I
No, no,
may,
there's no
with
question of
great
bullying.
respect, by the state here,
yes,
by the ED here, my lady, by the ED, by the Enforcement Directorate. Now, may I
I am
just say
not
this?
running away from arguing the petition.
Yeah,
I'm
may
saying
I
the
just
Supreme
say-
Court says of
please.
the
My
matter,
lady,
let it be
The
adjourned
Enforcement
to
Directorate
the
has
matter.
filed something in the Supreme Court. We are not party there. We do not know
Yes,
what they
you're on
filed.
caveat. I'm sorry, you're on
Yeah,
caveat.
Mr.
The copy has
Raju
been
says
served on
that,
you.
oh, it's been filed there, therefore you shouldn't
No,
hear
no,
this.
their
My lady,
copy
we
has
want
been
to
served.
say,
What is this? Copy has been served on them. They're on caveat. How can she argue that we don't know what?
I'm very sorry, Mr. Raju, we are not on caveat.
You are on
We
caveat.
are not parties. The Trinamool Congress is not on caveat.
That's the point.
Yes. Now, we are not on caveat. We are not a party. We do not know what the Enforcement Directorate has filed in the Supreme Court. We take Mr. Raju at his word, saying they filed something. Against whom, we don't know. But certainly not us. Now, why I am before my lady, and my lady, it is a privilege for me to be in your court for the first time today. Why I am before is that in this matter, which is the lead matter before you, I want to make 3 points. One, we are not a party in the Supreme Court. We are very happy to be heard by any court. Two, there was a search. Now, all we believe, we are not clear because, you know, the way the nature of these searches, we don't think anything has been
Well,
seized. If
leadership,
something
if
has
she's
been
claiming
seized, our
ignorance of
privacy
the
may be
petition in the
maintained
Supreme Court, let me
because
finish
it is data belonging to a political party. We live in a constitutional democracy. It's a contentious constitutional democracy. We
Madam,
are in
I've
opposition.
been
That
mute-
is the way
I've
it
been
is. We
muted.
want our
When I want to
political
speak, I've
data
been
to
muted.
be safeguarded. Many judges in Puttaswamy spent a long time hearing and finding that there is a right to privacy, including on the basis of political ideology. And political data forms a part of political ideology, which is protected by a very large constitution bench of this country. And it is constitutional jurisprudence and ethos in this country, which is at trial today. That is why I am before my lady, and that is why, Mr. Raju, I wanted to make my point,
No,
if
no.
you will allow me to.
As
So,
far as
Mr.
privacy is
Raju's
concerned,
argument that
it
we
has
are
been
before
dealt
the
with in
Supreme Court
the
on
challenge
caveat
was
is
made to Section
factually
70.
wrong. I am saying this as an officer of the court on the record. We are not a party, we are not in caveat. Now, what is before you is a matter which my lady may please hear and dispose of. We only respectfully request, as
My
a
lord, somebody
veteran
is
and
protecting me.
determined
This is totally
political
unfair.
party, that our political data be
Please
protected,
put on mute. If
not
this is the way
released,
proceedings
and
are
not
going on, how
released to
can
the
I argue?
media, and not used in a political fashion against us.
Again, I'm put on
This
mute.
is our
Again, I'm
political
being put
data.
on mute.
And in those terms, my lady, we respectfully come to my lady to then dispose of this matter as my lady sees fit. Because unlike Mr. Raju, I don't try to bully courts.
No, I never bully
So
courts.
I
I'm
want
sorry.
to be
Don't
very
impute
clear. So
something
that
which
is why I'm here
unwarranted.
today.
Totally false. How does she say that I'm bullying courts?
India
Where have I
challenge
bullied the court?
petition, so let me hear him.
No.
Very well, my lady.
May only submit, your ladyship may permit me to
Structure,
place on record the petitions which have been filed in the Supreme Court. Will the ladyship permit me?
Academic exercise which will happen. Let him speak. Huh, it has.
Mr. Banerjee has submitted that it has become.
Let him say.
That's not the submission of Ms. Dr. Goswami at all.
No, I'm saying we are not a party in the Supreme Court. That is what I'm saying.
For preservation of the political
How
data.
does she know? Without seeing my petition, how does she know?
Case status, Mr. Raju, case status.
What
It is
case
all
status?
available online now.
There is no case status. There is no case status.
And we are not on caveat.
Let me hear the Union of India, please.
Yes, please.
Yes.
First
Our
objection
petition may
is,
be disposed in those terms.
I
That
am-
as long as our data is protected, we have been heard. That is all we are asking for.
she is not Union of India. The court wants to hear of Union of India. Who is browbeating the court?
Union of India is here.
A second, my mic is being.
Yes.
Kindly takes
Kindly have a look. Kindly have a look, Your Ladyship.
Sir, Sir,
Every second, my mic is being muted.
ask you not to intervene, please. I request you not to intervene. Let me hear the Union of India.
I am also representing the Union of India. I am ED. I am the Additional Solicitor General. Let me make the submissions. I am representing both. Mr. Banerjee may supplement what I say. But as far as I am concerned, I am the Additional Solicitor General. I have the authority to represent the Union of India.
And what you have said. Let us
Yes,
hear.
now there is something I have not completed. She has barged in, and every time I want to speak, somebody who has the control of the mic switches off the mic. This is how the proceedings are going on. I'm sorry. It's a very sorry state of affairs. Every second my mic is being unmuted. This is not how the proceedings should go on in a court.
Lords Miller, can you take the repetition itself?
Yes.
Again, my mic is muted. I have strong objection. Why is my mic being muted when I'm speaking?
Not muted, sir. But please do.
Every time the ladyship will kindly see somebody is playing mischief. Somebody is playing mischief and muting my mic. This can't be done. This should not be allowed. This would amount to interference with the administration of justice. This may amount to contempt.
Your submission is going to the extent of disturbing the court proceedings, sir. I'm really sorry to say
I'm
this.
sorry, I'm not sorry. Let me make my submission. Now I'll make the submissions.
Hear him. He's challenging maintainability. Let me hear
Well,
him.
he is also my
Yes.
leader, my lord. He is the additional solicitor general of India.
Yes.
So,
Yes.
so far as maintainability point is concerned, my lord, Mr. Raju also may submit all these things.
Mr. Banerjee may submit, then I'll supplement what he says, my lord.
No. He's only on the point that it's Supreme Court is in
Supreme
session
Court,
of
when
the
the matter
matter.
is pending,
So
my
the
lord,
matter may be adjourned. That is his
matter is when the
point,
matter is
yes.
pending with the honorable
But you
Supreme
are
Court.
challenging maintainability.
I am challenging the maintainability itself, my
make
lord,
your
and
submission.
my second submission would be, my lord, when the matter is also pending with the honorable Supreme
Maintainability on what issue? Please
Maintainability
tell
on,
me.
yes, kindly take the writ petition itself.
Yes.
But this writ petition was filed by All India Trinamool Congress.
Yes.
Now, my lord, address is 30B Horish Chatterjee Street. My lord, your lordship would get the, my lord, address, my lord, in the cost title itself. Now, my lord, your lordship, my lord, kindly see paragraph 3, page 4.
Yes.
The petitioner is filing the instant writ petition is being aggrieved by the colorable exercise of powers by the respondents and for infringement of Article 21 of the Constitution of India 1950 to sabotage the fair process of West Bengal Legislative Assembly election 2026 in the garb of an alleged and purported search and seizure under Section 17 of the Prevention of Money Laundering Act 2002 at the office of IPAC being situated at Godrej Waterside, tower number such and such, West Bengal, as well as flat number 3, Lawton Street, Lawton Mansion, Lawton Street, Kolkata 17. So, my lord, the writ petitioner is basically espousing the cause, my lord, in respect of the search and seizure conducted at different place. The address is different, my lord. Your lordship, my lord, kindly tally the address. So far as these address and the writ petitioner's address is absolutely different. Now, my lord, kindly tell, my lord, next, my lord, paragraph, page 6.
Yes.
Page 6, my lord, after B and C, the last paragraph. It is thus apparent the seizure of such documents falling under the above mentioned categories shall have a severe impact upon the conducting the fair election process in ensuing West Bengal Legislative Assembly election 2026, and accordingly such improper and illegal seizure has caused severe prejudice to the petitioner herein. Now, if it is an election process, if we are infected the election process of 2026, ECI has to be made party in this case. Election Commission of India has not been implicated as a party in these proceedings. Now, the entire writ petition is based on 2026 election is yet to be notified. Now, may I just place? The petitioner has not received any notice from the respondent number 2 and 3 under the relevant provisions of the PMLA in the recent times, which entails the respondent number 2 and 3 to seize any relevant and confidential record document data of the petitioner. Relevant newspaper reports, my lord, annexed. Now, my lord, kindly see, my lord, next, paragraph 8. Page 8, paragraph 8.
Yes.
The petitioner states the petitioner has been actively involved in protesting and standing up against the harassment faced by the common man in the state of West Bengal due to the recent implementation of the SIR, the Special Intensive Revision process by the Election Commission. In the said implementation process is marked by mismanagement, capacity, misconduct, and maladministrations, inefficiency, and harassment for the common people of the state of West Bengal. Neither the Election Commission nor the central ruling party has any answer to the prolonged suffering caused due to such implementation. We have recently seen the people of Bihar were also subjected to similar harassment. It is only when the chairperson of the petitioner threatened to knocked on the door of the Honorable Apex Court, the respondent number 2 and 3 have come up with the unique idea of conducting the said search and seizure at the petitioner's political strategies office and its director's residence. So, my lord, this writ petition, my lord, basically, my lord, in respect of, my lord, SIR. Now, my lord, if it is in respect of SIR, my lord, then also, my lord, same thing will come, my lord, Election Commission of India is to be implicated as a party to these proceedings. Now, my lord, let me proceed further. Paragraph 9. Paragraph 9 says, my lord, petitioner further states the respondent number 2 and 3 are known to leak and share the confidential data relating to his investigations to the media and other stakeholders. The same has been widely reported, and such conduct on the respondents has been routinely criticized by the various courts of law. Such history of the respondent number 2 and 3 makes the petitioner even more apprehensive, since the respondent number 2 and 3 is deliberately engaged in a sham search seizure, operating only to gather the sensitive and confidential data of the petitioner. So, the search was conducted at the house of somebody else. the petitioner is coming saying that my data was there in respect of somebody's house. Now, well, the writ petition can be filed by a person whose right, legal right, fundamental right, or any other right has been infringed. By so what is the legal right, what is the fundamental right has been infringed in respect of this writ petition is concerned. Kindly see the prayers. Now, prior to that, Milord, kindly turn Milord page 10, paragraph 11 once. The petitioner states the confidential data which have been seized by the respondent number 2 and 3 form an integral part of the right to privacy as guaranteed on Article 21 of the Constitution of India. Moreover, the petitioner, being a recognized political party, being registered under the Representation of People Act 1951, is entitled to enlarge and participate in free and fair campaign and electoral process, which is an integral part of the democracy as guaranteed under on Article 19 of the Constitution of India. In the said conspector, it shows that without saying the political parties, much like the petitioners, are commitment on the democratic process, and therefore the conditions must exist where all the political parties, including the petitioners, can carry on its political activities on the just and powerful atmosphere. To halt and impair such democratic process and to restrain the petitioner to participate in the electoral process, the respondent number 2 and 3 have adopted such approach to steal the private and confidential data of the petitioner on the ground of the purported search and seizure procedure, which is partially illegal. Hence, it is a bounden duty of the petitioner to convert the overzealous protect to the right of the petitioner and consequently the protect and preserve such confidential data from being circulated or divulged to any entities at the behest of the respondent number 2 and 3. Now, paragraph 12 says, petitioner states the purported search and seizure operation carried out by the respondent number 2 and 3 is a colorable exercise of statutory power undertaking not for the purpose of justiciable investigations, for the oblique motive assessing and getting control of the confidential and sensitive data relating to the petitioner's electioneer's process. Now, kindly consider the entire writ petition is based on election. The entire writ petition does not say anything about the infringement of any fundamental right. Now, so far as data is concerned, whether I'm asking the question to myself, if the data was there at the office of IPAC, if it is seized by somebody while conducting the investigations, how it is connected to the petitioner? Now, kindly see the prayer. Prior to that, kindly see paragraph 14 once.
Yes.
Paragraph 14 says, the petitioner states that there is no proximity or casual nexus between the purported process of crime and the data and document information being seized by the respondent number 2 and 3. As such, the action and overaction on the part of the respondent number 2 and 3 in seizing the private and confidential and sensitive data information documents are expressly illegal. Now, somebody's data has been seized from the house of somebody. He should come forward. Now, in this petition, IPAC, kindly see who is the respondent number 4 in this petition. He has been implicated as pro forma respondent.
Yes.
There is no term in law known as pro forma respondent. So he is a respondent. The respondent number 4 should have filed a petition and saying that look here, the search seizure was conducted at my house. It is absolutely illegal. It is in violation of section 17 or section 50 of the PMLA Act. There is no petition has come forward. Respondent number 4 did not file any petition. Now kindly see the prayer. Kindly turn page 16.
Yes.
Kindly see page 16, prayer B. Prayer A, I am just a writ of or in the nature a writs or orders in the nature of mandamus declaring that the action and overaction on the part of the respondent number 2 and 3 to seize and continue to process private, confidential and sensitive data, information, documents of the petitioner and in relation to the operations, affairs, business of the petitioners in the graph of the purported search and seizure operation is banned and illegal. Next, can you see an order or a writ or order in the nature of mandamus directing the respondents to return all the articles including but not limited. Yes. But not limited to the private, confidential and sensitive data, information, documents illegally seized in the physical as well as electronic form belonging to the petitioners and or in relation to the operations, affairs, business of the petitioners illegally seized during the alleged search operation. Next, a writ or a writs in the nature of mandamus directing the respondent authorities to act strictly in accordance with the law and forbear themselves from harassing the petitioners and its main agent assigns in connection with the subject matter investigations and from taking any coercive steps against the petitioner and his main agents assigns on the pretext of ongoing investigation. My lord, read or reads in the nature of mandamus declaring that all actions taken by the respondent authorities so far as the petitioner and the private, confidential and sensitive data, information, documents of the petitioner and in relation to the operations, affairs, business of the petitioners illegally seized in physical as well as electronic form are as void and illegal. Read in the nature of prohibitions restraining the respondent authorities and their mail and agents dealing with and divulging, leaking, sharing informations from the seized article and data informations belonging to the petitioners and in relation to the operations, affairs and business of the petitioners in any manner whatsoever. Next, my lord, prayer G. A read reads in the nature of statutory directing the respondent authorities to produce the entire records pertaining to the subject investigations wherein the aforesaid search and seizure operation has been conducted and the private and confidential sensitive data, information, documents of the petitioners and in relations to the operations, affairs, business of the petitioners that have been illegally seized in physical as well as electronic form before the normal court so that the considerable justice may be done by passing orders as prayed for herein above. Now, will kindly see pair J. Interim order restraining the respondent authorities and their main and agents dealing with and divulging, leaking, sharing informations from the seized articles and informations belonging to the petitioners and in relation to the operation, affairs, business of the petitioners in any manner whatsoever. Now, my lord, interim order also asks for in terms of the pairs made in the earlier.
The petitioner is primarily on this prayer. now.
Yes. Now, my lord, kindly consider. one.
May I now supplement? Mr. Banerjee, let me supplement now, please. Yes, kindly let me supplement your leadership. May kindly first have a look at two points as far as the maintainability is concerned.
Yes.
The record, if any, which was seized by Mamta Banerjee. Therefore, these prayers of returning of the assets which are seized is not maintainable unless Mamta Banerjee is made a party. Because that is our case, that Mamta Banerjee to physically seized all the record and the digital devices from the premises and she has taken possession of them illegally and committed an offense, which petition is pending. Unless Mamta Banerjee is made a party who is in possession of illegal possession of these articles, these prayers and this writ petition is not maintainable. So in the absence of Mamta Banerjee being made a party, and in the absence of the DG of police and the police commissioner who have abetted the offense, if these prayers can't be granted because no record has been seized by the ED, all records have been seized illegally by Mamta Banerjee and her cohorts. Therefore, the first thing is this is not maintainable because Mamta Banerjee and the persons who have seized are not made parties. Secondly, kindly have a look at the affidavit at page 23.
Yes.
This petition is filed by a person who has no knowledge, who is a stranger, nothing. Now kindly look at the person who has filed the affidavit at page 23.
He has been
I, Subhashis Chakravarti, son of late P.P. Chakravarti, aged 68 years by faith, Hindu by occupation, self-employed and residing at 39 MG Road, so-and-so, Calcutta, 700822, hereby solemnly affirm and says as follows, that I am the authorized signatory of the petitioner. Kindly look at who the petitioner come back herein, that I am well acquainted with the facts and circumstances of the case. As such, I am competent to sign and affirm the affidavit. How does he become acquainted? He was not there at the search. He was nothing to do with the search. Now kindly have a look at the cause title and I'll show who is the petitioner is Trinamool Congress. Kindly have a look at page 1 of the petition. The petitioner is All India Trinamool Congress. So he is an authorized. Come back to page 23.
Yes.
He is an authorized signatory of the petitioner. Where is that authority? There is no authority produced along with the petition. That is the authorized signatory. And now further, how does he become well acquainted with the facts? Was he present when the seizure took place? Was he present when the search was taking place? Was he present in the so-called material was seized? No, he was not present. It's nobody's case. It's not even his case in the petition. I'll take your honor, ladyship, to that petition. I'll come to that a little later. Now he says, the statements contained in paragraphs 1 to 9, 17 and 19 are true to my knowledge. False statement on oath. He is supposed to be taken forward. He was not present anywhere. and rest are my respectful humble submission. Now kindly have a look at paras 1 to 9 of the petition. I will read the petition to show he was nowhere in the picture. He could not have filed this petition.
Yes.
Now kindly have a look after the points of law are concerned. Para 1. Petitioner is a recognized political party, namely All India Trinamool Congress. This is page 3 I am reading. Your leadership has got it?
Yes.
Petitioner is a recognized political party, namely All India Trinamool Congress, AITC, formed under Section 29A of the Representation of People's Act, represented by Mr. Subhashish Chakravarti being its authorized representative. The petitioner is currently in power in the state of West Bengal pursuant to a landslide victory in the West Bengal Legislative Assembly election 2021. Having defeated all the other rival political parties, including the Bharatiya Janata Party, petitioner is contesting the ensuing West Bengal Legislative Assembly elections 2026 by fielding candidates in all 294 assembly constituencies in the state of West Bengal. The petitioner has its office at the address mentioned here. The respondent numbers 1 to 3 are the state within the meaning of Article 12 of the Constitution of India, and as such are amenable to the writ jurisdiction of this honorable court. Respondent numbers 2 and 3 are commonly known as Enforcement Directorate, which is responsible for conducting investigations under the PMLA.
Getting to point out, sir.
No, because I'm showing that he has made a false affidavit of what he has said, does not disclose that he has knowledge about the such and such, therefore false affidavit. Therefore, I have to read these paragraphs. Para 3. The petitioner is filing this instant writ petition being agreed by the colorable exercise of powers by the respondents and the infringement of Article 21. He said, this is true to my knowledge. This is true to his knowledge. Fair procedure of West Bengal Legislative Assembly 20 in the garb of all alleged and purported search and seizure under Section 17 of Prevention of Malundering. The fact that Section 17 powers, what powers they have, are pending. This is pending before the Supreme Court in the matter of TASPAC. That also I'll point out. This very issue about the scope and power of Section 17, which is there, is challenged before the Supreme Court, is pending. The Supreme Court is seized with this matter on Section 17. Now, your ladyship may kindly have a look, referred to as PMLA, at the office of IPAC being situated Godrej Water site so-and-so, as well as flat number 3 so-and-so. So it is at some other place, as my colleague Mr. Banerjee has pointed out, nothing to do with Trinamool Congress. And the person whose premises are seized has not come before your honor and complained about the seizure. Kindly note this. Petitioner states that the Indian Political Action Committee, IPAC, is a professional political consulting organization, provides strategic research, communication on ground of campaign to support political parties, leaders across India. In the process, the group helps them set a citizen-centric agenda, partners with leaders to conceptualize and implement the most effective methods of taking it to the public and gathering mass support. IPAC has been associated with the petitioner for approximately 6 years, providing end-to-end 360 degrees campaign support.
Sir, not the entire writ petition. I have
No,
gone
I'm saying, because he said paras 1 to 9, I'm showing that this doesn't show anything about his.
through the entire writ petition.
I'm not reading the entire. I'm saying showing the paragraphs which he said paras 1 to 9 is what he refers in the affidavit. He says this is true to my knowledge. Now kindly have a look. How does he get the knowledge? How is he concerned? Not a whisper. Not a whisper in the entire petition. Now kindly have a look at a judgment of this honorable court which is binding to your ladyship. CRM SB 53 of 22. My colleague must be giving a copy to your ladyship.
Yes,
The judgment.
sir is referring to.
Apex Marine Services LLC versus State of West Bengal.
Actually, you are addressing, that's why.
It's not a-
There's a break now.
Till my learned friend gets a printout, my lord, may I proceed further, my lord?
Sir, I'm just
Now,
giving a copy.
you've given a copy to the honorable court.
So you kindly refer the judgment. I'll give the copy here and now.
The judgment is CRM SB 53 of 2022.
Sir.
In application and in the matter of Apex Marine Services LLC,
Is that the citation, sir? Citation would be
it is
useful.
unreported judgment. Versus State of West Bengal.
I'm saying. Putting. Okay. It is for everybody. It is unreported order in CRM SB 53 of 2022, dated 19/4/2022, in the matter of Apex Marine Service LLC and Prabhu Shipping Lines Private Limited versus State of West Bengal. I am handing over a copy to Mr. Banerjee on my tab. Please, I'm getting the printout. Please accommodate.
CRM SD 53.
Sir, you may proceed.
Now kindly have a look at, I am reading from the second page, second paragraph. I'll read from second. At the outset, Mr. Ayan Bhattacharya, learned advocate for respondent number 2 has raised a technical objection. He takes me to page 22 of the application for cancellation of bail. Page 22 of the said application contains affidavit sworn by the constituted attorney of the complainant petitioner. In para 2 of the affidavit, the deponent has made the following affirmation: that the statements made in para 1 to 30 are information derived from the record, which I verify and believe to be true, and rest are my humble submission before this honorable court. It is submitted to Bhattacharya, learned counsel for the respondent, that the application contains 31 paragraphs, out of which paragraphs 1 to 30 are stated to be information derived by the deponent from the records. Mr. Bhattacharya then refers to various paragraphs of the application. That is why I was referring to those paragraphs, not because I wanted to delay the proceedings, because the affidavit contains that it is to my knowledge, paras 1 to 9. Mr. Bhattacharya then refers to various paragraphs of the application, submit that statements made by the petition and the application for cancellation of bail cannot be said to be a matter of record, as the application is not informed. Mr. Bhattacharya praised that outright rejection of the same. In support of the contention, he refers to Rule 27 and 28 of Chapter 4 of the Appellate Side Rules. The above mentioned rules are quoted below. 27. When the declarant in any affidavit speaks of any fact within his knowledge, he shall do so directly and positive, using the words I affirm and say. When the particular fact is not within the declarant's own knowledge, but is stated from information obtained from others, the declarant shall use the expression I am informed, and if such be the case, should add and verify believed to be true. So nothing is from his knowledge. His derived information, and this portion of Rule 28 is violated. And he must also state the source from which he received such information. When the statement rests on facts disclosed in documents or copies of documents procured from any court of justice or other source, the deponent shall state what is the source from which they are procured and its information or belief as to the truth of the fact disclosed in such documents. Copies of documents other than those on record of the case to which it is in.
Supplementary affidavit. The petitioner was allowed to cure the defect by filing a supplementary affidavit. The writ petition was
I
not.
have not received it. I have to be given, therefore let it be adjourned. I have to have a look at the copy of the affidavit. If it does it behind my back,
In this matter, the petitioner was directed to file a supplementary.
I am not aware of this. This is coming for the first time to my knowledge. Your ladyship, I must know what is the affidavit that he has filed.
No, sir. Honorable Court is referring to the judgment which you are citing. Factual
Yes, I'm sorry. Judgment, yes. That was. I'm sorry. I'm sorry. My ladyship is referring. Yes. Therefore, let me read 28. I'll complete the judgment. I'm so sorry. I'm so sorry, your ladyship.
Please come to the concluding part.
I'm just let me read this, please. When the particular fact is not within the Rule 28, when the particular fact is not within the declarant's own knowledge, but stated from information obtained from others, the declarant shall use the expression "I'm informed," and if such be the case, should add and verify, believe it to be true. And he must also state the source from which he receives such information. When the statement rests on facts disclosed in documents or copies of documents procured from any court of justice or other source, the deponent shall state what is the source from which they were procured, and his information or belief as to the truth of the facts disclosed in such documents. Copies of documents other than those on record of the case to which it is intended that reference should be made at the time of hearing shall be annexed to the affidavit and is marked as exhibit, as an exhibit shall bear the certificate of the commissioner before whom the affidavit is made. It is further submitted by Mr. Bhattacharya that in view of the provisions contained in Article 215 of the Constitution of India, the High Court is a court of record. Therefore, defective application cannot be retained in the record, and such application should be rejected. And further refers to a decision of the Constitution Bench of the Supreme Court in State of Bombay versus so and so. Paragraph 16 of said decision is relevant. We wish to, however, observe that the verification of affidavit produced here is defective. The body of the affidavit discloses certain matters are known to the secretary who made the affidavit personally. Verifying, however, states that everything was true to the best of the information belief. We pointed out this slipshod verification of the type might well be given in a case lead to rejection of the affidavit. verification should variably model in the lines of Order 19, Rule 3 of the CPC, whether code applies in terms or not. And then in subsequent case in LR Shivama Ramagowda and others versus TM Chandrasekhar by and LRs and others reported in 1999, 1 STC 666 at page 672, the Honorable Supreme Court made the same observation. Mr. Imtiaz, learned advocate of petitioner, does not dispute that the affidavit was wrongly found by the deponent. He prayed the liberty to file a supplementary affidavit to rectify the error. Now, your ladyship is right. Here, there is no such prayer. Now, I'll take to your ladyship what is the implication of this affidavit. I'll come to that. Situation as to whether the application will outright to be rejected for the error or defect of the affidavit is dealt with by the court in so and so, reported in so and so. It is observed that the court, while considering rule so and so, affirmation not made as per rules 27 is curable defect and leave the is granted to remove the said defect in the affidavit before the commissioner by filing supplementary affidavit. Then, in view of the above decision of this court interpreting rules 27 and 20 of chapter 4 of the appellate side, the court is of the considered view that no fruitful person served with the application and about technical ground, the defect may be cured and directly respondent to supplement the affidavit in accordance with the appellate side rules. It has to be cured. Therefore, before entertaining this application, the defect has to be cured. I'll tell you, why in the present case the defect can't be cured, because the defect goes to the root of the matter. It is a false affidavit leading to perjury, which would entail filing of an application under 340 of the CRPC. Now, kindly have a look at the petition again. The petitioner is not concerned, not the petitioner, the person who has filed the affidavit is not concerned, not present at the places of search. The places of search are at the residence of one Pratik Jain and the office of IPAC. He has nothing to do with these two premises. Therefore, search conducted by the ED in those two premises, he is not concerned. He is not a representative of either Pratik Jain or IPAC. Therefore, he is unconnected with the place of search, number one. Number two, it is not his case that he was present during the time and place of search.
He has
So
never said that.
Therefore, the petition is not. I am obliged. Therefore, the petition is not maintainable. How can a third person who has not seen anything, not done anything, not knowing anything, file a petition, make allegation? Therefore, the petition is. I am obliged to this question from my leadership. The person is unconnected to the incident. Person unconnected to the incident who has no knowledge, no information, doesn't say that he received information from some source. Even if he has said that and revealed the source, it would have been a different matter. Doesn't say that. Therefore, the petition is filed by an incompetent person who could not have filed the petition and who could not have sworn to the correctness of the facts in the petition. The person who files a petition must be one who should be able to swear to the correctness of the facts stated in the petition. That person would be a person with knowledge, would be a person who has derived information from some source. If he falls in the second category, he must disclose the source. This is not done. He doesn't fall in the first category because it is not first-hand information. He was never present anywhere. Therefore, the petition is not maintainable on the face of it by a person who had nothing to. How does he know that any documents were seized? How does he know that anything was seized? It is his imagination.
May I respond, my lady?
No, no.
Right, sir. That's all
Yes.
your
I have not completed. Let me complete. Therefore, the petition by a person who doesn't know what has happened, who was not present at that place, who doesn't rely on any source information to make these averments, has filed the petition. Therefore, on this limited ground alone, the petition is required to be rejected. This is one point. Now, kindly have a look.
Point of
Get the task matter. As to the scope and power of the ED to conduct a search, the Supreme Court is seized.
maintainability issue, nothing further at the moment.
No, I'm making I'm giving the submission.
Part of the ED for now. We are only on maintainability of
Yes,
the
I'm on maintainability. I'm on maintainability as far as this petition is concerned.
play now.
Task matter petition law.
Writ petition 23 of 24.
There is writ petition 23 of 24, where the scope of section 17 of the PMLA is being examined by the Supreme Court. Kindly have a look at section 17 of the PMLA. Your
That's a
lady-
different issue altogether, sir. I will not deal with that at the moment.
No,
I'm
no,
on-
I am saying this is the issue of search. Kindly look at the prayers. It
I'm
is
only on
directly concerned with the prayers. Kindly have a look at section 17 on the prayers.
the maintainability issue. I'll hear the other side now.
This is no, I've not completed my maintainability issue.
Please
I
confine
have
your
not
argument.
completed. Your ladyship may say that without allowing me to complete, your ladyship wants to hear the other side, your ladyship may
I
do so.
don't hear
But
the
I have
side.
not completed my submissions on maintainability.
Please confine your argument to maintainability.
Yes, I'm confining my submissions to I'm addressing on merits. I'm not addressing on merits. Now, therefore, to maintainability, now kindly come back to the prayer, your ladyship.
So that has already been pointed out by your junior.
Therefore, I'm pointing out from that one. Your ladyship may kindly have look.
It's already pointed out, sir. Do you want to add anything to that?
Yes, I'm adding on it. The prayer is to declare inter alia the action of the ED to seize and continue to possess private, so-called private, confidential, sensitive data. Where, what is the sensitive data? Nothing, as vague as anything. What was the sensitive data seized by ED? Nothing.
I'm sorry, you're
I'm on the maintainability. I'm on the maintainability now.
repeating your. You've made these points already.
No, he has not made this, but what has been said, it is on the ground of vagueness also the petition is required to be rejected, that the petition suffers from the vice of vagueness without specifying what is the data seized, what is the private data seized by ED. The petition would suffer from the vice of vagueness, and if it suffers from the vice of vagueness, it is required to be rejected at the threshold. Secondly, your ladyship may kindly have a look. The power to seize flows from section 17 of the PMLA Act. That's power to seize under section 17 with what powers the ED has, whether the ED has powers to seize sensitive data or not.
Please do not make these submissions now, sir.
If
Please
your
confine your argument to
ladyship may cut my submissions, record it. I have no objection. My ladyship may record that you're not allowing me to make full submissions and cutting me in the nip.
Absolutely, absolutely.
Your ladyship may say so.
Only on maintainability that we are
I
dealing.
am arguing on maintainability. I know my limits. I am arguing on maintainability. I am not exceeding my limits. But still, if your ladyship wants to curtail me, nip me in the bud, that's your lady's prerogative. I can't say anything. But I am addressing your ladyship only on maintainability. Your ladyship may prevent me. I will bow down to, because ultimately I have to bow down to the wishes of your ladyship. But my submission is that I am making submissions only on maintainability, and those submissions I am not being permitted to be made.
To section 17 and the powers of ED.
Now, therefore, I'll tell your ladyship on maintainability as far as section 17 and powers of ED is concerned. Your ladyship may hear me. The power to search and seize flows from section 17 of the PMLA Act. What is the scope of section 17 is being examined by the Supreme Court. Get the other judgment.
Sir, please do not reiterate your submission, sir.
I'm not reiterating.
Many times.
No, I am not. I will not repeat.
Spending time for nothing. Please do not do this. We are aware that the Supreme Court is in session of the matter.
Ram Ramaswamy.
Yes. Your ladyship is right. I have said the Supreme Court is session of the matter.
Not dealing with section 17 here.
No, but they're not. Kindly, therefore, I'll point out how this petition pertains to section 17. Kindly look at the prayer and then I'll show what section 17 is. That is their cleverness. They've drafted it in such a manner that section 17 does, but the powers flow from section 17. The powers to search and seize flow from section 17. Whether you have the right to seize, search is being examined by the Supreme Court in another batch of petitions. I will give the writ petition number. Therefore, kindly have a look at the prayer in the context of what is prayed for. Two types of prayers are made, your ladyship. One is regarding the power scope of ED to seize certain types of documents. Second is their case that private confidential documents are seized. Therefore, this can't be done. These two, both these matters are sub judice before the Supreme Court. I'll point out those two judgments, not the judge.
Only on one now, sir. I hope you have heard the submissions.
No.
The petitioner only asks for preservation of the political data, allegedly political data.
Grateful.
That's all.
Now kindly, I'm obliged. If your ladyship is confining
That's
me,
the
it
prayer
is, hear me for a minute,
Thank you.
why this is not maintainable.
Grateful.
Why this prayer is not maintainable, hear me for a moment. Now, maintaining data would arise if I've seized the data, if it is in my possession.
So you have already said that, sir. You have already made that submission.
Therefore, if it is not seized, how can I maintain it? Therefore, the petition is
But
not
the-
maintainable because it makes false averments that I've seized data. The data is seized by Mamata Banerjee. The prayer should be made against Mamata Banerjee. In fact, we would like that prayer to be made. We'll support them if they make that prayer against Mamata Banerjee. Therefore, where is the averment that we have seized it? What data we have seized? What data we have to be? The courts cannot give a direction to seize something which is vague and which is not certain. We have not seized. I am making a statement. ED has not seized anything because when we wanted to seize, after taking into possession, Mamata Banerjee has taken away those documents and digital devices. That is our case before the Supreme Court.
Time, sir. I have taken a note of.
Therefore, the prayer against us is not maintainable. Therefore, the petition is not maintainable as far as preservation of data. If what data we have to preserve, we have not seized anything. We don't have possession of anything. Therefore, my statement may be recorded.
That's all. I'll record.
Introduction. Therefore, that prayer is therefore the petition is not maintainable.
Very well. Let me hear
Can I
the.
respond,
Now,
my
there are
lady?
two things. I'll finish off early as far as two other submissions are concerned. Number one, what we can say is when we can search is subject matter of petition of TASMAC, which is writ petition number 23. What is the writ petition?
Anything to add?
I will, which is writ petition number 395 of, no, that is the other, TASMAC. TASMAC petition. Kya hai?
Anything to add, sir?
No, this is.
So that's.
I'll give the number of petitions which are pending on this point. SLP criminal 80448 of and 8049 of 2025. This is TASMAC regarding the power and scope of ED to seize and search documents. That is 80. Then, as far as Supreme Court guidelines for search and seizure of digital devices pending before the Supreme Court, may I give the case numbers? Foundation of Medical Professionals versus Union of India, writ petition criminal 395 of 22. Then Amazon Sellers Services Private Limited versus Directorate of Enforcement, writ petition civil 1081 of 22. TPK News Click Private Limited versus Union of India, writ petition criminal 679 of 23. Future Gaming and Hotel Services Private Limited versus Directorate of Information, writ petition criminal 515 of 24. I'll give a list. View Now Infotech Private Limited versus ED, writ petition criminal 63 of 25. State of Tamil Nadu versus Director of Enforcement, special criminal number, SLP criminal number 7958 of 25. And the last one is the TASMAC. So all these matters in the Supreme Court are seized with the powers of ED to seize documents, including private documents. This matter is live and kicking before the Supreme Court. Therefore, when the matter is live and kicking before the Supreme Court, the judicial propriety requires, not in the second matter also, that this honorable court should not hear the matter. That is the judgment of D.K. Trivedi.
Second matter is your matter, sir. I'll adjourn it on your prayer.
No, even the first matter, I am on the first, I am conscious. Second matter also, all these judgments and all this I'm citing with respect to the second matter. First matter is our own petition.
First matter is no longer on merits now. They are requesting a very limited direction. So let me hear, sir. Let me hear
No,
the.
I'm on the verge of completion.
May I respond now?
I'm on the verge of completion. As far as my ladyship has not understand and I'm not made myself clear as far as what I'm submitting. I'm submitting as far as second petition is concerned. As far as second petition is concerned, all the issues which they have raised is live and kicking before the Supreme Court in large number of cases, the list of which I've just mentioned orally. That is with respect to second petition. Now, if such a
Now,
petition
may I
is
just
pending,
respond, Mr. Raju, to your eloquent arguments?
kindly have a look at one last judgment, then I'll be over. 1986, supplementary SCC, page 20. para 83.
1986.
1986, supplementary SCC, page 20, para 83. I have said that the issues in the second petition are being argued and heard before the Supreme Court.
Yes, you're referring to paragraph?
Paragraph 83 of this judgment. This is not with respect, I should not be misunderstood. It is with respect to the second batch of petitions. First batch, your ladyship is clear, I am obliged for that. Second batch of petitions. Civil appeals 1525 and 1526 of 1982 are directed against the order of the Gujarat High Court dismissing the writ petitions filed by the appellants challenging the constitutionality of section 15 of the Mines and Minerals Regulation Development Act 1957 and validity of notification number so and so dated June 8, 1881, and directed the appellants to approach the Supreme Court as similar matters were pending there. In our opinion, the course adopted by the High Court was not correct. If the High Court thought that the point raised by the appellants was the same as was pending in this court, it ought to have stayed the hearing of the writ petition until this court disposed of the other matters. So if I pointed out that similar matters are pending before the Supreme Court with respect to the second petition. First petition is my matter. Second petition, I pointed out on the scope of 17 petitions are pending. There's item number 2. I'm making submissions to item number 1. Item number 2 is mine, where your ladyship is with me as far as adjourning the matter is concerned. With respect to item number 1 is concerned, I pointed out that the issue of section 17 is pending before the Supreme Court. Issue of seizure of sensitive data, how it is to be done, private is also pending before the Supreme Court. If that is pending, in view of this judgment of the Supreme Court, which is binding, this matter should be adjourned till those matters are decided. And one more judgment in this point.
Just respond, my lady, now.
Now,
Before
one more
we
judgment.
Get to 4 p.m.
One more judgment. I'm sorry, I have not completed. Where are I? No, all right, leave it. This is all that I have to submit on maintainability. And my further submission is, I may be permitted to file an affidavit on maintainability before your ladyship decides to hear the matter. I want to file an affidavit and bring everything on record and point out all those petitions which are there. Your ladyship may grant me time to file an affidavit and place all this material on record, and thereafter your ladyship may hear the other side, because this is a preliminary objection which I have raised. Orally I have raised. I want to put everything on affidavit. I want to produce all those documents, and I want to show the Supreme Court judgment and show everything which I have stated.
Come back with an affidavit.
I'll come back.
My lady, may I just respond to Mr. Raju's arguments?
Till then, the hearing may
Yes.
be kept on.
I have a request.
Yes.
Come back with an affidavit with all these issues, with all these points.
I'm just going to take 2
I'll
minutes, my
come back.
lady. 2 minutes.
I'll come
It's
back.
unclear to me. But may I just
I'll
take
come back.
2
Your
minutes?
ladyship may give me about 2 weeks' time. I'll come back.
Nothing is required, my lady. May I just make 2 points? One, Mr. Raju's statement may be recorded as he's appearing for the Enforcement Directorate that nothing was seized. He has asked my lady to record that. I will also join him in this request. It is probably
there
the
was
only
present.
request we'll ever make
Cover
together
everything.
on something. So that's the first point. The
Yes,
second point
I
is
will not
this.
make a wrong
The
statement.
Yes, absolutely. I know you won't make a wrong statement.
I said
Therefore,
it
I'm
is not in my
respectfully
possession.
requesting.
It is not in my
Now, please
possession.
don't interrupt me, Mr. Raju. I didn't interrupt you. I heard you. Now, please don't interrupt
Suggesting
me.
something, yes.
So, the first thing I want to say is please record that statement. The second thing I want to say is our petition was of a very limited nature, that of protecting personal political data which is relevant to a well-established political party that ED may have seized. That is the width of it, and that is protected by Puttaswamy. That is the second. It's para 11 of our petition. I'm not going to read the petition. It's been read to my lady too many times today for such a short petition. I imagine what would have happened if Keshavananda's petition was read and reread in this fashion. But be that as it may. Point 3, and I want to make this point. It is inappropriate and unbecoming to bully a political party which has filed a petition at the time when it believed that personal data of that political party relevant to the upcoming assembly elections was being housed by their political strategists, not of yesterday or day before, but for the past 6 years. It is a well-founded fear that we had, and that is why we came to court. Then 4, on the issue of the affidavit, the authorization letter for this member of the Trinamool Congress has been filed with our wakalat. Mr. Raju could have asked his instructing lawyers to just check this. The authorization letter has been filed, and that authorization was given by a National Working Committee member of the party. And this person who has signed the affidavit is a member of the party. There is nothing, no great conspiracy
no
here.
knowledge, no
We
information.
all want to have free and fair elections. We find it suspect that our political strategist office was targeted in this way a few months before the assembly elections. I want to be clear. That is the
It's
fear
our
here.
case that money laundering
We
has
are not
been
here on the
shelter of money
scope
laundering
or
in the
the
guise of political
constitutionality.
election.
Don't interrupt me.
No, no,
We
I'm
are not
telling
here
you,
on the scope.
this has
Or please
nothing to do
mute
with-
yourself
nothing
then.
to do with- She's not
Please
admitting
mute
her
yourself.
penalty. She's not
Please mute
admitting her
yourself.
penalty.
All right, this is
You're admitting
unbecoming conduct.
penalty.
And the
Our
next
case is
time
that
you
the
want to,
state
as
gets
law
money
officer,
laundering. It did not
refer
want the
to a
money laundering
sitting
to
chief
surface upon
minister
the guise
by
of
her
elections
name,
of state.
give her the dignity of calling her the chief minister of a state, a multi-term chief minister. There is a certain decorum to be maintained in a courtroom, Mr. Raju. I want to be clear here. This is what I'm
Merely
on.
because you say there is
The
no decorum doesn't
affidavit
mean that
has
there is
been
no decorum.
filed by a member of a political party, authorized. That letter of authorization has been filed with the Wakalatnama. That is on the record.
case is-
All we are here, if Mr. Raju is going on the record and saying that nothing has been seized, then please record that statement. We then believe that maybe political data was seized from our political
My statement
strategist,
may be
which
recorded.
is
Nothing has been
indicative to
seized
the
from-
assembly elections. That is all I'm here. If that statement has been made, our petition may be disposed of in those terms, that nothing has been seized. I'm grateful for my lady's patient hearing.
Raju sir, bolte rao. No, no.
Lord, may I just submit only one? I have been instructed to submit before your lordship.
You're appearing for?
Union of India, I am.
I will not
am
hear to
submitting-
so
I am
many
not-
counsels for the
I am
Union
not
of India. I'm
submitting a
extremely
single
sorry.
word. I am not submitting a single word, only the instruction. Which
No,
has
no,
come.
your ladyship, I'm sorry.
I am not saying
He has
anything.
made a statement that on my
Sir,
statement,
Tiwari-
of the petition, nothing
But-
survives. Nothing survives. On my statement,
Counterpart.
Whatever argument Mr. Tiwari has made, he is.
senior advocate of the Supreme Court has made a statement that on my statement, the petition is
Cannot take
withdrawn, let
cognizance
it be done.
Court of Mr. What
I'm
is?
sorry. I'm sorry, my lord. Why is he interrupting in the middle of the statement? Now, on my statement, your ladyship may hear me. On my statement that we have not seized anything
Instruction, I
from
am
these two
submitting.
premises, the petition may be withdrawn as stated by the learned counsel for the petitioners. Let there be sanctity to what has been stated in the court. I have made my statement and I abide by my statement and let them abide by that their statement that they're withdrawing the
Sir, kindly
petition.
The other
Please,
one-
we are not withdrawing anything,
No, you
Mr.
said that.
Raju.
I'm sorry.
Please record. No,
I'm
I did
sorry.
not say that. Do
Well,
not put
you
words in
said
my
it.
mouth.
I'm so sorry.
My
Now,
lady,
on
please
hindsight,
record the
don't make a
statement
wrong
that
statement.
nothing
I'm
was
so
seized.
sorry.
And in those
I
terms,
discussed-
it may
heard
be
her.
disposed of.
But
Mr.
the lady
Raju
heard
obviously
her. She
does
said,
not
"I'm
know the
withdrawing if
difference
that statement is
between
made,
disposed
accepted."
of and withdrawal. I am
I'm sorry,
surprised.
I'll put it on affidavit. Let the proceedings be, let
I
the recording of
request
the
all my
proceedings be
friends to
shown. He has
slightly
made a statement.
let Raju sir speak because he's wanting to make a last submission which may be of relevance.
How long? How long Mr. Raju will?
How will Mr. Raju submit?
How long Mr.
My
Raju?
submission
The
is
last
this.
submission will be
I have
of
made a
much
statement. Your
importance if
ladyship
my
may
lord wants
kindly
to take
see.
office as
I
well.
have made a statement that we have not seized anything from these two premises at the time of the search. On that statement, my colleague,
This is really.
Anika has said that she's withdrawing the petition. She has
I
made-
never said that,
she has
Mr.
made that
Raju.
statement.
I
That
never
statement
said
is
that. You
made,
are
and
having
therefore the
momentary
petitions do
amnesia.
not survive.
Yes,
Sorry.
you are having momentary
Petition.
amnesia.
No,
I
no,
never
don't go
said that.
back.
I
Don't go
said my
back.
lady
I'm
may
very
record
sorry.
your
She has
statement.
made
It
that
may be
statement.
disposed of. It
No.
may be disposed
may
of in those
adjourn the
terms.
matter
Disposed
today.
I
of.
am very
Doesn't matter.
surprised
It
you
is
don't know the
disposed of.
difference between disposed of and withdrawing.
Yes, it may be disposed of. I'm obliged. Let it be disposed of on my
Very well. My
statement.
lady
I'm
may please
obliged.
record that statement.
Yes,
Please record that statement that nothing was seized.
yes. My
And that
statement
the
will be
ASG
recorded
is
and
making
the
that
disposed of
statement.
may also be recorded. I have no objection.
Sir, please make your submission now.
My submission is,
He's been submitting for
I am on
Naranda.
instructions that nothing has been seized
Let me-
on these two premises, the residence of Pratik Jain and IPAC on the date of the search, that is 8th of 8th of January 26, nothing, no record, no digital device has been seized. And on that statement, the statement of the petitioner's counsel is the petition may be disposed of in view of that statement. I am obliged. Let the matter be
That is
disposed
what
of.
I was trying to impress upon my lord, that here, Mr. Raju, just for the, because that can be of very much importance for this honorable court, my lord.
You cannot, are you differing with Mr. Raju?
My lord.
Are you differing with Mr.
No,
Raju?
yes, my lord, I am appearing in adherence. Yes, my lord, yes, whatever Mr. Raju is saying.
That nothing has been seized by the ED.
My lord,
Yes.
Yes.
Yes, I am making a statement. ED officers are with me. I am making a statement. Mr. Trivedi, it's all right.
Please record that statement, my lady. We'd be grateful.
Nothing has
Please
been
record his
seized
statement.
on 8th of January from these two premises in the raid, and all whatever was taken into possession has been taken away by Mamata Banerjee.
This is in consonance.
So it says that nothing was seized from the premises.
By the ED.
We are not able to.
The ED only to assist your lordship.
And everything was taken away by Mamata Banerjee.
Yes, this is the search and seizure.
The Panchnama also says that nothing was seized.
Yes,
Record that.
Yes,
yes.
Please talk, my lord. This is the reason why I said it will take 1 minute.
See, the clock has also stopped.
Time has stood still, my lady, in this courtroom today. We've had causeless read out multiple times.
Add some- yes.
I am appearing on in
The
the
second matter,
second matter.
which
so
is
for-
being adjourned.
So yes, there is I have submissions. Well, my submission is this, Milord. Firstly, Milord, I am appearing on behalf of Mamata
Mr.
Banerjee.
Gordon, I will give you 2 minutes. Let me finish up the first matter.
No
Finish up the
problem.
first matter.
I
And
don't
then
have.
we'll get back to
I
you.
don't
I'll
have
get
it.
back to you.
Give your blessing.
My lord will kindly dictate it on the
ভাই,
mic.
হাত জোর-
Just
তোদের
now,
হাত জোর
yes.
করছি ভাই
Yes.
তোদের হাত সেন্ট্রাল গভর্নমেন্টকে হাত জোর
Outside the court, Hajjo, not in court.
Yes.
Heard learned counsels for the parties. The only prayer of the petitioner in the writ petition is for preservation of the political confidential data and protection of the same from being circulated or divulged to any entity at the behest of the second and third respondents. Paragraph. The other prayers in the writ petition are not pressed by the petitioners. Paragraph. Learned counsel for the respondents submits, comma, on instructions, comma, that nothing whatsoever was seized from the two premises in question by the authority
On the search made on 8th of January 26.
pursuant to the search,
Search is made.
2026.
And whatever was seized by Mamata Banerjee. That is my statement.
Is copies of the Panchnamas drawn up by the Enforcement Directorate,
My lord, we are
At
not
the
sure. It
two
was submitted
places
by
of-
Mr. Ganguly.
pro forma respondent. I've recorded that. Pro forma respondent, yes. কি বলে? Panchnamas drawn up at the places of alleged search and seizure, which demonstrate that nothing was seized from either the office of the pro forma respondent or the residence of, he's the, what is his designation?
Jain is the probably director.
The director of the company.
The
Director of
director of the
IPAC.
respondent 4. Director of respondent 4. One of the directors of respondent 4.
in view of such submission made on behalf of the respondents, comma,
Mm.
nothing further remains to be dealt with in the present application. Stop, the same is accordingly disposed of.
Grateful, my lord.
May I
I'm
only
so
submit
grateful,
one
my
thing?
lady.
Your Lordship?
Very
May I only
grateful.
submit one thing? My statement that whatever was there was seized by Mamata Banerjee may also be recorded. My statement that whatever seized was seized by
It's my
Mamata Banerjee.
petition, my lady.
Yes,
Why is he
that
trying
is
to
what
dictate
Mamata
the
Banerjee
order?
did.
She's
That
not
is
the chief
record.
minister is not a party here.
Our matter.
So
My statement may be recorded in full, Your Ladyship. Why part recording of my statement?
This is
My
not some
statement is we have
political
not seen
theatre.
what is seized by Mamata Banerjee. Therefore, Trinamool Congress will have to file a
Your
case against Mamata
petition number
Banerjee.
2 is there. You argue all this there, Mr. Raju.
That is different. This is a different petition. You have said that it's a
Same
different
petition,
petition.
Mr.
Not there.
Raju,
You're not
two
a party in
sides.
You're not a party in
Please
that.
argue this there.
address.
ওর সাথে add করুন, and no data backup was taken.
Grateful.
Grateful. Very grateful.
Yes, now,
Now,
My
Madam-
lady, very grateful. Thank you for your time.
Yes,
Madam-
I'm
grateful,
adjourning,
madam.
adjourning the second
I'm
matter.
I'm obliged to your ladyship for a
Just,
I'm obliged to your ladyship for a patient hearing.
just 3 minutes,
Forest
and I will request your lordships, if your lordships just consider that any of my submission is recorded, my lord, that's all.
I'm
Nothing more.
simply adjourning the matter, Mr. Bandopadhyay, so you can.
What,
come back on the
no,
next-
what, just minute.
May I only submit this, your ladyship?
That's,
Your
that's,
ladyship,
my lord, kindly
I'm
say the
thankful for
hearing is in
I'm thankful for a patient hearing,
Hearing-
your ladyship.
progress, matter is
My lady,
adjourned.
here all, I join Mr. Raju also. We are both
Hearing is
thankful for a
progress.
patient hearing.
The
Right.
Supreme Court is in session of.
No,
the matter.
I am coming. That is the reason I am coming. Exactly, I want to say this thing. But firstly, let me very much clear myself that I am appearing on behalf of the chairperson of the All India Trinamool Congress, Mamata Banerjee, not the Chief Minister Mamata Banerjee. He is the chairperson of. They have wrongly.
In which matter my learned friend is appearing?
What
I'm
is
sorry,
that?
which matter are you
Please
appearing in?
don't interfere.
I want to know which matter
don't
you are appearing.
interfere.
I'm not interfering, I'm only asking.
এ কি গো, সব সময়তে
Patience, patience.
I should know which matter. Is there a matter
Now,
pending?
see, this petition was on 9th in the morning. It was leave was
Petition are disposed of. Is he arguing a dispose of matter?
Presenting 3, 4 and 5. You're appearing?
State and the officers.
officers.
So that's 3, 4 and 5.
Yes, yes.
The
4 and 5, we have no notice.
আরে ভাই আমাকে একটু বলতে দাও।
Since he's asking for an adjournment, let me
Yes.
adjourn the matter for some time.
My lord, but yeah, lordships can adjourn, but I am submitting only that hearing of the petition 2 is also commenced. That's I am saying, submitting. Initially, I have said if item 2 hearing has been commenced. I am nothing. I am saying. Then the map, because of the paucity of time, matter is adjourned. That's not. No, I am just suggesting.
Technicality.
my lord, I am just
that's fine.
My lord, I am just.
Don't have anything
My lord,
to
I am just suggesting.
Item 2, Trinamool Congress is not a party. Is appearing for whom in number 2?
My lord, this is very important. Why I am saying. Why I am
He has,
saying.
he has no locus. Is appearing for whom? You are appearing for whom, Mr. Bandopadhyay? You are appearing for
Has
whom?
been given by the ED to the court, to this court. Therefore, my lord, kindly see paragraph 12.
Atmosphere, here the matter.
কোন
in High Court, therefore we are before. the-
Page N.
This is.
They kindly see. Joseph দাও কোনখান থেকে
I made that statement.
Left hand side page top. 17, 18, 19.
Number 17, kindly see, may I read it? The petitioner enforcement directorate had approached the Honorable High Court by filing a petition on Article 226 of the Constitution of India. However, before the matter could be taken up by the High Court, enormous disturbance was created inside the courtrooms, organized through a WhatsApp group by supporters and sympathizers of the ruling party of West Bengal.
Order, nothing else. They have recorded my, this is my
No,
order.
that's right. Malad, this is allegation.
There
That
is no local. Trinamool Congress is not a party.
aforesaid fact is also evident from the order.
Why is he allowed to even argue?
What is this?
Yes, what is this? I should ask you. I should ask you. The court has said the matter is being adjourned. How can you argue even if you are not a party? How can you argue even if you are not a party? Have you filed an impleadment application? Have you filed an impleadment application?
The proceeding is being live.
Maybe, Malad, when the
And you are
Trinamool Congress is not a party in the second matter. He has no
What I
locus
am
to address the
submitting,
court.
when
Taking
the
advantage.
matter will be going on in the Supreme Court, that the honorable judges of the Supreme Court will not look into the video. They will go only.
How he can say what the Supreme Court judges will do? Who is it to say what the Supreme Court judges do or not? Recently, we played some videos
I
before
am
the Supreme Court.
my observation
In
that.
two matter, Umar Khalid, we played videos, number of videos. In PFI matter, we played videos. How is he making statement what the Supreme Court judges will do or not?
Therefore, Malad, therefore,
Such
if
thing,
the ground has been
I
taken,
strongly object to such
my lord,
things.
at least Malad, this is my.
What the Supreme Court will do, they will ask my learned friend and do.
Sought for by them.
What nonsense.
Kindly record to that extent. Adjournment has been sought for by them.
He is not a party. Trinamool Congress is not a party. It should not be heard. I do not know why he is being given this leniency.
On the ground that the enforcement directorate has filed SLP, special leave petition, before the Honorable Supreme Court, and with prayers which are almost identical to that of the present application. Stop. The Honorable Supreme Court is in session of the matter. Paragraph in view of the above, comma. The matter is adjourned. Liberty to mention after the matter before the Honorable Supreme Court is disposed of.
Grateful, I'm
Milord,
I'm
can
obliged for a patient,
I-
your ladyship.
want to proceed with the matter?
Please
Can you
record.
record that, Milord? Milord, we are willing
He's
to.
not a party, he's not a party. How can he proceed upon a non-party can proceed? Appearing for
Has
whom?
no substance.
The respondents
Learned additional sources general
are
submission
ready
has
and
no
willing
substance at all.
to proceed with the matter before
Of
this.
course. You are the one who decides what has to be done, what substance I have, what the Supreme
Really
Court.
very grateful, my lady, for such a patient
I'm
hearing.
grateful for patient hearing. I'm sorry I had to argue a little loudly because of the video disturbance. I'm grateful. I'm obliged.
I'm so grateful, my lady. Happy New Year to everyone.
21 ki 26 ago.
After is
Happy New Year. Happy Sankranti.
disposed of. Amir, can you-
Yes, happy Sankranti, Mr. Raju. Let's not forget our own festivals. Yes, happy Sankranti.
I think it's a bit unnecessary.
Yes, all right.